Part 3 Claims. Chapter I General Provisions. Section 1 Subject of Claims. Article 373, Subject of Claim. Even something the value of which cannot be computed in money may be the subject of a claim. Article 374, Duty of obliger to deliver specific thing with good manager's care. If the delivery of a specific thing is the subject of a claim, the obliger is bound to preserve such thing with the care of a good manager until it is delivered. Article 375, Claim in Species. 1. Where the subject of a claim is designated in species only, and its quality cannot be determined by the nature of the juristic act or by the intention of the parties, the obliger is bound to perform with a thing of medium quality. 2. If in the cases mentioned in the preceding paragraph the obliger has completed all acts that are necessary for the performance or has with the consent of the obligee designated a thing to be performed, such thing shall thenceforth constitute the subject matter of the claim. Article 376, Pecuniary Claim. Where the subject of a claim is to be delivered in one kind of currency, and the currency has ceased to be legal tender at the time the claim becomes due, the obliger is bound to effect payment in another currency of legal tender. Article 377, Pecuniary Claim in Foreign Currency. 1. Where the subject of a claim is to be delivered in foreign currency, the obliger may, at his option, effect payment in any kind of currency of the country. 2. When the subject of a claim is to be delivered in one kind of foreign currency, and the currency has ceased to be legal tender at the time when the claim becomes due, payment shall be effected in some other currency of the country. Article 378, Pecuniary Claim in Foreign Currency. If the amount of a claim is designated in foreign currency, the debtor may effect payment in Korean currency at the current rate of exchange at the place of performance when the delivery is made. Article 379, Legal Rate of Interest. The rate of interest of a claim bearing interest, unless otherwise provided by other acts or agreed by the parties, shall be 5% per annum. Article 380, Alternative Claim. Where the subject of a claim is to be determined according to option from among two or more acts, unless otherwise provided by other acts or agreed by the parties, the right of option shall vest in the obliger. Article 381, Transfer of Right of Option. 1. Where the period for the exercise of a right of option is specified, and the party having a right of option fails to exercise it within the period, the other party, having determined a reasonable period, may give peremptory notice to make an option. Where the party having a right of option fails to do so within the reasonably fixed period, the right of option shall be vested in the other party. 2. Where the period for the exercise of a right of option is not specified, after the claim has become due, the other party, having determined a reasonable period, gives peremptory notice to make an option, and the party having a right of option fails to do so within such period, then it becomes identical with the preceding paragraph. Article 382, Exercise of Right of Option by either party. 1. Where an option is made by the one party, it shall be made by the declaration of intention to the other party. 2. The declaration of intention mentioned in the preceding paragraph cannot be revoked without the consent of the other party. Article 383, Exercise of Right of Option by Third Person. 1. Where an option is made by a third person, it shall be made by the declaration of intention both to the obliger and to the obligee. 2. the declaration of intention mentioned in the preceding paragraph cannot be revoked without the consent of both the obligee and the obliger. Article 384. Transfer of right of option vested in third person. 1. Where a third person cannot make an option, the right of option shall be vested in the obliger. 2. Where a third person does not make an option, the obligee or the obliger may notify him to make an option within a reasonably fixed period, and if the third person fails to do so within the period, the right of option shall vest in the obliger. Article 385. Specification of alternative claim owing to impossibility of performance. 1. If, among two or more acts of performance which are to be made under an option, some of which have either been impossible to perform in the beginning or subsequently become impossible to perform, the subject of the claim shall exist in respect of the remaining acts. 2. The preceding paragraph shall not apply, if any act of performance has become impossible by reason of the negligence of the party who does not have the right of option. Article 386. Retroactive effect of option. The option shall be effective retroactively from the time the obligation arose, provided that the right of a third person may not be prejudiced thereby. Section 2. Effect of claim. Article 387. Time for performance and delay of performance. 1. Where a definite time for the performance of a claim is fixed, the obliger shall be responsible for delay as from the commencement of such time. If an indefinite time for the performance of a claim is fixed, the obliger shall be responsible for any delay as from the time when the obliger has become aware of the arrival of the time for performance. 2. If a time for the performance of a claim is not fixed, the obliger shall be responsible for the delay as from the time when demand for performance has been made upon him. Article 388. Forfeiture of benefit of time. The obliger cannot claim the benefit of time under the following circumstances. 1. If the obliger has damaged, diminished or extinguished the security, and 2. If the obliger has failed to perform the obligation of furnishing the security. Article 389. Compulsory performance of obligation. 1. If an obliger does not perform his obligation voluntarily, the obligee may apply to a court for compulsory performance thereof, provided that this shall not apply to where the nature of an obligation does not so permit. 2. If the obligation mentioned in the preceding paragraph has a juristic act for its subject, application may be made to a court for a decision which shall act as a substitute for a declaration of intention by the obliger. If it has an act which is not entirely personal to the obliger for its subject, application may be made to a court to compel performance by a third person at the expenses of the obliger. 3. Where the obligation has nonfeasance for its subject, and the obliger has violated it, application may be made to a court to have that which has been violated by the obliger removed at the obliger's expense, and that reasonable precautionary steps be taken against future repetition. 4. The preceding 3 paragraphs shall not affect a demand of compensation for damages. Article 390. Non-performance of obligations and compensation for damages. If an obliger fails to effect performance in accordance with the tenor and purport of the obligation, the obligee may claim damages, provided that this shall not apply to where performance has become impossible and where this is not due to the obliger's intention or negligence. Article 391. Intention or negligence of performance assistant. Where a legal representative for the obliger effects performance in lieu of the latter or the obliger effects performance through the other person as an employee, the intention or negligence of the legal representative or the other person shall be deemed as that of the obliger. Article 392. Compensation for damages arising from delayed performance. The obliger shall be responsible for damages during delay of the performance even where he is not at negligence, provided that this shall not apply to where the damage is inevitable even if he performed at the time when the time of performance became due. Article 393. Scope of compensation for damages. 1. The compensation for damages arising from the non-performance of an obligation shall be limited to ordinary damages. 2. The obliger is responsible for reparation for damages that have arisen through special circumstances, only if he had foreseen or could have foreseen such circumstances. Article 394. Method of compensation for damages. Unless otherwise agreed by the parties, the damages shall be recovered in money. Article 395. Performance delay and compensatory damages. Where the obliger has delayed the performance of an obligation, and the obliger fails to perform within a reasonably fixed time that the obligee has given notice, or performance after delay is no longer profitable for the obligee may refuse to accept performance and claim damages in lieu of performance. Article 396. Contributory negligence. If there has been any negligence on the part of the obligee in regard to the non-performance of the obligation, the court shall take it into account in determining the liability for and assessing the amount of the damages. Article 397. Special rules as to non-performance of monetary debt. 1. The amount of damages for non-performance of a monetary debt shall be determined by the legal rate of interest, provided that where there exists an agreed rate of interest which does not exceed the limitation provided by acts and subordinate statutes, that agreed rate of interest shall prevail. 2. With regard to the damages mentioned in the preceding paragraph, the obligee is not bound to prove the actual damages, nor can the obliger set up the absence of negligence as a defense. Article 398. Liquidated damages. 1. The parties may determine in advance the amount of damages payable in the event of the non-performance of an obligation. 2. Where the amount of damages determined in advance is unduly excessive, the court may reduce the amount to a more reasonable and appropriate sum. 3. The determination in advance of the amount of damages shall not affect the obligee's demand for performance or rescission of the contract. 4. The agreement of a penalty is presumed to be determined in advance of the amount of damages. 5. Even where the parties have agreed beforehand that something other than money shall be applied as compensation for damages, the provisions of the preceding paragraphs shall apply mutatis mutandis. Article 399. Obliger's subrogation to obligee owing to compensation for damages. If an obligee has received by way of damages the full value of the thing or right which forms the subject of the claim, the obliger shall ipso jure be subrogated to the position of the obligee in respect of such thing or right. Article 400. Mora creditories. If an obligee is unable to accept performance of an obligation or refuses to accept it, such obligee shall be responsible for the delay commencing from the time when the performance has been tendered. Article 401. Mora creditories and responsibility of obliger. If the obliger has no intention or gross negligence in respect of non-performance, such obliger shall, during the obligee's delay of acceptance, be free of all responsibility arising as a result of non-performance. Article 402. Obligee's acceptance delay and responsibility of obliger. During a period of delay on the part of the obliger is not bound to pay the interest even though the obligation is accompanied by the interest. Article 403. Mora creditories and responsibility of obligee. If the expense for the custody of the subject matter or for performance is increased owing to the delay on the part of the obligee, the amount of the increased expense shall be deducted from the account of the obligee. Article 404. Obligee's right of subrogation to obliger. 1. An obligee may, in order to preserve his claim, exercise the rights belonging to the obliger, provided that this shall not apply to such rights as are strictly personal to the obliger. 2. Before a claim becomes due, the obligee cannot exercise the rights mentioned in the preceding paragraph without the court's permission, provided that this shall not apply to an act of preservation. Article 405. Notice as to exercise of obligee's rights of subrogation to obliger. 1. If the obligee, according to the provisions of the paragraph 1 of the preceding article, has exercised the rights, except the act of preservation, he is bound to give notice to the obliger. 2. After the obliger has received the notice under the preceding paragraph, even though he has disposed of his rights, this shall not be so set up against the obligee. Article 406. Obligee's right of revocation. 1. If the obliger has performed any juristic act which has a property right for its subject, with the knowledge that it would prejudice the obligee may apply to the court for its revocation and restitution of its original status, provided that this shall not apply where a person who has derived a benefit from such act or a subsequent purchaser was, at the time of the act or of the purchase, unaware of the fact that it would prejudice the obligee. 2. The action mentioned in the preceding paragraph shall be brought within 1 year from the time when the obligee became aware of the cause for revocation, or within 5 years from the time when the juristic act was done. Article 407. Effect of revocation by obligee. The revocation and restitution of its original status according to the provisions of the preceding article shall take effect for the benefit of all obliges. Section 3. Several obliges and obligers. Subsection 1. General provisions. Article 408. Relationship of divisible claims. Where there are several obliges or obligers, they shall, in the absence of any other agreement, have rights or assume duties in equal proportions. Subsection 2. Indivisible claims and indivisible obligations. Article 409. Indivisible claim. Where the subject of a claim is indivisible by its nature or by a declaration of intention by the parties, and there are several obliges, each obligee may demand performance on behalf of all the obliges, and the obliger may effect performance to any obligee on behalf of all the obliges. Article 410. Effect of facts arisen to one of obliges. 1. Among the obliges having indivisible claims, an act done by, or any fact concerning any one of the obliges, except the fact which has an effect upon all the obliges according to the preceding article, shall have no effect upon the other obliges. 2. Where a novation or a release has been effected between one of the obliges having indivisible claims and the obliger, other obliges who have received performance of the entire obligation must reimburse the obliger that which would have been allocated to such obligee if he had not lost his right. Article 411. Indivisible obligations and provisions applied mutatis mutandis. Where several persons assume an indivisible obligation, the provisions of Articles 413 through 415, 422, and 424 through 427 as well as those of the preceding article shall apply mutatis mutandis. Article 412. Conversion into divisible claim and divisible obligation. Where an indivisible claim or obligation is converted into a divisible one with respect to the obliges or the obligers, each obligee may demand performance only in respect of his own share, and each obliger shall be liable for the performance only in respect of the share incumbent upon himself to perform. Subsection 3 Joint and several obligation. Article 413, Content of joint and several obligation. If each of the several obligers has the responsibility to perform the entire obligation, and the performance by one of the obligers discharges the other's obligation, the obligation shall be a joint and several obligation. Article 414, Demand for performance against each of obligers jointly and severally liable. The obligee may demand performance, in whole or in part of the obligation, against one of the obligers jointly and severally liable or all of them simultaneously or in succession. Article 415, Nullity or voidance in respect of obligers. The ground for nullifying or avoiding a juristic act in regard to one of the obligers jointly and severally liable, shall not affect the other's obligation. Article 416, Absolute effect of demand for performance. A demand for performance made upon one of the obligers jointly and severally liable shall be effective as against the others. Article 417, Absolute effect of novation. If a novation has been effected between one of the obligers jointly and severally liable and the obligee, the claim shall be extinguished in favor of all the obligers. Article 418, Absolute effect of set-off. 1. Where one of the obligers jointly and severally liable has a counterclaim against the obligee, and the obliger makes a set-off, the claim shall be extinguished in favor of all the obligers. 2. If the obliger who has a counterclaim does not make a set-off, the other obligers can make a set-off only to the extent of his share of the obligation. Article 419, Absolute effect of release. A release of an obligation given to one of the obligers jointly and severally liable, shall be effective in favor of the other obligers jointly and severally liable only to the extent of his share of the obligation. Article 420, Absolute effect of merger. If a merger has taken place as between one of obligers jointly and severally liable and the obligee, the other obligers jointly and severally liable shall also be relieved of their obligation only to the extent of the share incumbent upon such obliger. Article 421, Absolute effect of extinctive prescription. If extinctive prescription has been completed for one of the obligers jointly and severally liable, the other obligers jointly and severally liable shall also be relieved of their obligation only to the extent of the share incumbent upon such obliger. Article 422, Absolute effect of mora creditories. The obligee's acceptance delay against one of the obligers jointly and severally liable, shall be effective upon the other obligers jointly and severally liable. Article 423, Principles as to relativity of effect. Except for matters mentioned in the preceding 7 articles, all other matters relating to one of the obligers jointly and severally liable shall not be effective on the other obligers. Article 424, Equality of contribution. The extent of the share incumbent upon the obligers jointly and severally liable to contribute, shall be presumed as equal. Article 425, Right of reimbursement of obliger who has performed at his own expense. 1. If one of the obligers jointly and severally liable has, by performance of the obligation or otherwise at his own expense, procured a discharge for common profit, he is entitled to reimbursement from the other obligers jointly and severally liable in proportion to their respective shares. 2. The right of reimbursement mentioned in the preceding paragraph shall include legal interest as from the day of discharge, and the expenses or other losses which were unavoidable, or other compensation for damages. Article 426. Notice as requisite for reimbursement. 1. Where one of the obligers jointly and severally liable has, without notifying the other obligers jointly and severally liable, procured a common discharge by performance or otherwise at his own expense, and one of the other obligers had a defense available against the obligee, he may set it up against such obliger as has done an act for discharge only to the extent of the share incumbent upon himself, and if the ground for defense so set up is a set-off, the claim which is to be extinguished by a set-off shall be transferred to such obliger as has done an act for discharge. 2. Where one of the obligers jointly and severally liable fails to notify the other obligers jointly and severally liable that he has procured a common discharge by performance or otherwise at his own expense, and one of the other obligers jointly and severally liable has in good faith effected performance or otherwise procured a discharge for value, he shall insist upon the effectiveness of his own act for discharge. Article 427. Share incumbent upon obliger who is insolvent. 1. If one of the obligers jointly and severally liable has no sufficient means to make reimbursement, the part which he is unable to pay shall be borne by the person demanding reimbursement and the other solvent obligers in proportion to their respective shares, provided that if the party demanding reimbursement is at negligence, he cannot demand the other obligers jointly and severally liable to bear their proportionate shares. 2. In the case of the preceding paragraph, if one of the other obligers who are to bear the part for reimbursement of the obliger, who is insolvent, has obtained a release by the obligee from his joint and several liability, the obligee shall bear the part incumbent upon the obliger. Subsection 4. Surety obligation. Article 428. Contents of surety obligation. 1. A surety is liable to perform the obligation upon which the principal obliger has defaulted. 2. A suretyship may be made for a future obligation. Article 429. Extent of surety obligation. 1. The surety obligation shall include interest on the principal obligation, penalty, damages, and all other charge incidental to the principal obligation. 2. A surety may stipulate in advance the amount of penalty or other liquidated damages in regard to his own surety obligation. Article 430. Appendant nature of surety obligation. If the burden of a surety is greater than that of the principal obliger either as to its subject or its terms, it shall be reduced to the extent of the principal obligation. Article 431. Requisite as to surety. 1. Where an obliger is bound to furnish surety, such surety must be a person who has full capacity and sufficient means to effect performance. 2. If the surety ceases to have sufficient means to effect performance, the obligee may demand substitution of another for such surety. 3. Where the obligee has designated the surety, the provisions of the preceding two paragraphs shall not be applicable. Article 432. Furnishing other security. The obliger may be released from liability to furnish a surety by furnishing other reasonable security in lieu thereof. Article 433. Surety and defense of principal obliger. 1. A surety may avail himself of any defense against the obligee which the principal obliger has against the obligee. 2. A waiver of a defense by the principal obliger shall not be effective as against a surety. Article 434. Surety and right to set off of principal obliger. A surety may avail himself of any claim which the principal obliger has against the obligee as a set-off against the latter. Article 435. Surety and right to revocation, etc. of principal obliger. So far as the principal obliger has the right of revocation, rescission or termination against the obligee, the surety may refuse to perform the obligation against the obligee. Article 436. Surety as to voidable obligation. Where a surety has guaranteed an obligation which is voidable and of which he was aware at the time of entering into the suretyship, and there exists non-performance or revocation of the principal obligation, he is presumed to have assumed an independent obligation of the same tenor as the principal obligation. Article 437. Defense by surety of peremptory notice and inquiry. If an obligee has demanded performance of the obligation from the surety, upon proving that the principal obliger has sufficient means to effect performance and that the execution would be easy, the surety may enter a plea as a defense that the obligee must demand from the principal obliger and that he must first levy execution on the property of the principal obliger, provided that if the surety has assumed an obligation jointly and severally liable with the principal obliger, this shall not be apply. Article 438. Effect of laches as to peremptory notice or inquiry. Notwithstanding that a defense has been made by a surety in accordance with the provisions of the preceding article, and the obligee has, owing to his laches, been unable to obtain partial or full performance from the obliger, the surety shall be relieved of his liability to the extent that the obligee would have received performance, if he had not been negligent. Article 439. Benefit of division by co-sureties. Even where several sureties have assumed their liabilities for one obligation by separate acts, the provisions of Article 408 shall apply. Article 440. Effect of interruption of prescription against surety. An interruption of prescription against the principal obliger shall also be effective as against the surety. Article 441. Right of reimbursement of fiduciary surety. 1. If a surety who has become such at the request of the principal obliger has, without negligence on his part, caused the principal obligation to be extinguished by performance or at his own expense, such surety shall have a right to be indemnified by the principal obliger. 2. Article 425. 2. Shall apply mutatis mutandis to the cases mentioned in the preceding paragraph. Article 442. Right of preliminary reimbursement of fiduciary surety. 1. A surety who has become such at the request of the principal obliger may exercise in advance his right of reimbursement against the principal obliger in one of the following subparagraphs. 1. When a surety has, without his negligence, had judgment entered against him ordering performance to the obligee. 2. If the principal obliger has been declared bankrupt, and the obligee does not participate in the bankrupt estate. 3. If 5 years have elapsed after the conclusion of the contract of suretyship, where the time for the performance of the obligation is uncertain and even its maximum duration is unascertainable, and 4. If the time for the performance of the obligation has arrived. 2. In the case of subparagraph 4 of the preceding paragraph, no time granted by the obligee to the principal obliger after the conclusion of the contract of suretyship can be set up against the surety. Article 443. Demand for discharge by principal obliger. Where a principal obliger indemnifies the surety in accordance with the provisions of the preceding article, he may demand of the surety to discharge the obligation for him or request of the surety to furnish security, or he may relieve himself of his liability of indemnification by making a deposit of the amount of indemnification, furnishing security or procuring a discharge of the surety. Article 444. Right of reimbursement of non-fiduciary surety. 1. Where a person who has become surety without the request of the principal obliger, has performed the obligation or has otherwise, at his own expense, procured the discharge of the principal obliger, the latter is liable to indemnify the surety to the extent that he was enriched as of the time of discharge. 2. Where a person has become surety against the will of the principal obliger, has performed the obligation or has otherwise at his own expense procured the discharge of the principal obliger, the latter is liable to indemnify the surety only to the extent that the latter is still being enriched. 3. If, in the preceding paragraph, the principal obliger claims that he had, prior to the demand for indemnification, a good cause for set-off against the obligee, the claim, which would have been extinguished by such set-off, shall be transferred to the surety. Article 445. Notice as requisite for reimbursement. 1. Where a surety has, without notifying the principal obliger, performed or otherwise procured a discharge of the principal obligation at his own expense, and the principal obliger had a defense available against the obligee, he may set it up against the surety, and where the defense so set up is a set-off, the claim which would be extinguished by the set-off shall be transferred to the surety. 2. Where a surety has not notified the principal obliger that he had performed the obligation or otherwise procured at his own expense a discharge, and the principal obliger has in good faith effected performance to the obligee or otherwise procured a discharge for value, the principal obliger may treat his act of discharge as effective. Article 446. Duty of notice of discharge to surety of principal obliger. Where the principal obliger has not notified the person who has become a surety at the request of the principal obliger that he has obtained a discharge by his own act, and the surety has in good faith effected performance to the obligee or otherwise has procured a discharge for value, the surety may treat his act of discharge as effective. Article 447. Right of reimbursement of person who has become surety for one of obligers jointly and severally liable or of indivisible obligation. A person who has become surety for one of the obligers jointly and severally liable or of an indivisible obligation is entitled to be indemnified from the other obligers only in proportion to their respective shares. Article 448. Right of reimbursement among co-sureties. 1. Where there are several sureties, one of whom has effected performance in excess of the share incumbent on him, the provisions of Article 444 shall apply mutatis mutandis. 2. Where the principal obligation is indivisible or each surety has assumed the obligation for which they are jointly and severally liable to each other or with the principal obliger, and one of the sureties has effected performance in excess of the share incumbent on him, the provisions of Articles 425 through 427 shall apply mutatis mutandis. Section 4. Assignment of claim. Article 449. Assignability. Nature of claim. 1. A claim may be assigned, except where its nature does not so permit. 2. Where the parties have declared a contrary intention, a claim shall not be assigned, provided that such declaration of intention cannot be set up against a third person acting in good faith. Article 450. Requisite for setting up assignment of nominative claim against obliger. 1. The assignment of a nominative claim cannot be set up against the obliger or any other third person, unless the assigner has given notice thereof to obliger or the obliger has consented thereto. 2. The notice or consent mentioned in the preceding paragraph cannot be set up against a third person other than the obliger, unless it is put in writing with a certified fixed date. Article 451. Effect of consent or notice. 1. If the obliger has given his consent as mentioned in the preceding article without reservation, he cannot set up against the assignee any defense that he could have set up against the assigner, provided that if the obliger has paid anything to the assigner for the discharge of his obligation, he may recover it, and if he had incurred a new obligation to him, he may treat it as if it had not been incurred. 2. Where the assigner has merely given notice of the assignment, the obliger may set up against the assignee any defense which has arisen against the assigner prior to the receipt of the notice. Article 452. Notice of assignment and estoppel. 1. If an assigner has given notice of assignment of a claim to the obliger, even where assignment has not been made or the assignment is null and void, an obliger acting in good faith may be set up a defense which can set up against the assignee, against the assigner. 2. The notice mentioned in the preceding paragraph cannot be withdrawn without the consent of the assignee. Section 5 Assumption of obligation. Article 453. Assumption of obligation by contract with obligee. 1. A third person may assume an obligation by contract entered into with the obligee and thereby discharge the obligation for the obliger, except where its nature does not so permit. 2. A third person who has no interest in the obligation cannot assume an obligation against the will of the obliger. Article 454. Assumption of obligation by contract with obliger. 1. Where a third person has taken over a debt by contract entered with the obliger, it shall be effective as from the time when the obligee has given consent thereto. 2. The other party to whom the obligee's consent or refusal shall have effect upon, shall be the obliger or a third person. Article 455. Peremptory notice to confirm of whether to consent or not. 1. In the case of the preceding article, the third person or the obliger may request the obligee to answer whether he will consent or not within a reasonably fixed period. 2. If the obligee has not sent a definite answer within such reasonable period specifying whether to consent or not, it shall be deemed as a refusal. Article 456. Withdrawal or change of assumption of obligation. The parties may withdraw or change the assumption of an obligation according to a contract between a third person and the obliger by the time of the obligee's consent. Article 457. Retroactive effect of assumption of obligation. The consent of the assumption of the obligation by the obligee shall, if there exists no different declaration of intention, be effective retroactively as from the time of such assumption, provided that the retroactive effect may not harm the rights of a third person. Article 458. Ground for defense of former obliger. A person assuming an obligation may set up a defense against the obligee which the former obliger could have set up. Article 459. Assumption of obligation and extinction of suretyship or security. A suretyship for the obligation of the former obliger or the security furnished by a third person shall be extinguished by virtue of assumption of the obligation, unless the surety or the third person has given consent thereto. Section 6 Extinction of claim. Subsection 1 Performance. Article 460. Method of tender of performance. Performance must be effected by way of actual tender in strict accordance with the tenor of the obligation, provided that where the obligee previously refused its acceptance or where an act of the obligee is required for the performance of the obligation, it shall be sufficient to inform the obligee that all preparations have been made for performance, and give a peremptory notice to him of its acceptance. Article 461. Effect of tender of performance. A tender of performance shall relieve the obliger from responsibility for non-performance as from the time of such tender. Article 462. Delivery of specific thing in its existing condition. If the delivery of a specific thing is the subject of the obligation, the obliger must deliver the thing in the condition in which it exists at the time when the delivery thereof is due. Article 463. Delivery of thing belonging to another as performance of obligation. An obliger who has delivered a thing belonging to another by way of performance of an obligation cannot demand the recovery of such thing, unless he effects a valid performance anew. Article 464. Delivery of thing by its owner who has no capacity to dispose of it. Where the owner of a thing who has no capacity to dispose of it has delivered it by way of performance, and then such performance has been avoided, He cannot demand the recovery of such thing unless he effects a valid performance anew. Article 465. Consumption or assignment in good faith by obligee and right of reimbursement. 1. If, in the cases mentioned in the preceding two articles, the obligee has consumed or disposed of in good faith the thing which he had received by way of performance, the performance shall be effective. 2. If, in the cases of the preceding paragraph, the obligee has been demanded by a third person to pay damages, he may exercise the right of reimbursement against the obliger. Article 466. Accord and satisfaction. Where an obliger has, with the consent of the obligee, done an act of performance different from, and in substitution for the one originally intended, such act shall be deemed a valid performance. Article 467. Place of performance. 1. If the place of performance has not been decided by the nature of the obligation or the declaration of intention of the parties, the delivery of a specific thing must be made at the place where the thing existed when the obligation arose. 2. In the cases of the preceding paragraph, performance of the obligation other than the delivery of a specific thing must be effected at the present domicile of the obligee, provided that the performance of the obligation in regard to the business shall be effected at the present business place of the obligee. Article 468. Performance prior to time for performance. In the absence of the declaration of special intention by the parties, the obliger may effect performance even prior to the time when performance becomes due, provided that he must compensate for the damage of the other party. Article 469. Performance by third person. 1. The performance of an obligation may also be effected by a third person, provided that if its nature does not so permit, or the parties have declared a contrary intention, this shall not apply. 2. A third person who has no interest in the obligation cannot effect performance against the will of the obliger. Article 470. Performance to quasi-possessor of claim. A performance made to a quasi-possessor of the claim is effective only if it was done in good faith and without negligence. Article 471. Performance to bearer of receipt. A performance made to the bearer of a receipt shall be effective even where he is not authorized to accept performance, provided that this shall not apply to where the person effecting performance was aware or should have been aware of the fact that the bearer did not have such authority. Article 472. Performance to unauthorized person. Except in the cases mentioned in the preceding two articles, a performance made to a person who is not authorized to accept it is effective only to the extent that the obligee has been enriched thereby. Article 473. Bearing expenses of performance. In the absence of a special agreement, the expenses of performance shall be borne by the obliger, provided that where the expenses of performance is increased by changing the obligee's domicile or by his any other act, the amount of such increase shall be borne by the obligee. Article 474. Claim of receipt. A person effecting performance may demand a receipt from the person accepting the performance. Article 475. Claim of return of document evidencing obligation. If there exists a document evidencing the obligation, the person effecting performance in full may demand the return of such document. This shall also apply where the obligation has been extinguished in full by any cause other than performance. Article 476. Designated appropriation of performance. 1. If an obliger owes to the same obligee several obligations whose subject is of the same kind, and the tender of performance is insufficient to discharge them all, the person effecting performance may, at the time of performance, designate the obligation to be discharged by appropriating performance for it. 2. If the person effecting performance makes no such designation as mentioned in the preceding paragraph, the person accepting the performance may at the time of acceptance designate an obligation to be discharged by appropriation of performance, provided that this shall not apply if the person effecting performance immediately objects to such designation and appropriation. 3. The appropriation of performance mentioned in the preceding 2 paragraphs shall be effected by a declaration of intention made to the other party. Article 477. Constructive appropriation of performance by law. If the parties have not designated the obligation to be discharged by appropriation, it shall be done in accordance with the provisions of the following subparagraphs. 1. If some of the obligations are due and others are not due, it shall be appropriated for the performance of the obligation which is due. 2. If all the obligations are due or all are not due, it shall be appropriated for the performance of the obligation the discharge of which is most advantageous to the obliger. 3. If the advantage to the obliger is equal, it shall be appropriated for the performance of the obligation which first became due or will become due, and 4. If the facts mentioned in the preceding 2 subparagraphs are equal, it shall be appropriated for the performance of each obligation in proportion to the amount of each obligation. Article 478. Appropriation of insufficient performance. The preceding 2 articles shall apply mutatis mutandis where 2 or more acts of performance are necessary for the discharge of one obligation, and those acts for performance which have been effected are insufficient to satisfy the entire obligation. Article 479. Order of appropriation of performance to expenses, interest and principal obligation. 1. If the obliger is to pay expenses and interest of one or more obligations, and the person effecting performance has effected insufficient performance to satisfy the entire obligation, such performance shall be appropriated in the order of the expenses, the interest and the principal. 2. Article 477 shall apply mutatis mutandis to the case mentioned in the preceding paragraph. Article 480. Voluntary subrogation by person who has performed obligation. 1. A person who has performed an obligation on behalf of the obliger may be subrogated to the rights of the obligee with the consent of the latter, which should be obtained simultaneously with the performance. 2. The Articles 450 through 452 shall apply mutatis mutandis to the case mentioned in the preceding paragraph. Article 481. Constructive subrogation by act of person who has performed obligation. A person who has a legitimate interest to effect performance shall be by operation of law subrogated to the rights of the obligee by effecting the performance. Article 482. Effect of subrogation by person who has performed obligation. Relations among subrogators. 1. A person who has been subrogated to the rights of the obligee in accordance with the provisions of the preceding 2 articles may exercise the claim and the right in respect to its security to the extent to which he may be reimbursed by virtue of his own right. 2. The exercise of the right mentioned in the preceding paragraph shall be subject to the provisions of the following subparagraphs. 1. A surety cannot be subrogated to the rights of the obligee as against the third person who acquired of the right on an article which is the object of chanseguan or mortgage unless the subrogation has been entered in advance into the registration of chanseguan or the mortgage. 2. A third-party purchaser cannot be subrogated to the rights of the obligee as against a surety. 3. One of the third-party purchasers shall be subrogated to the rights of the obligee as against the other purchasers in proportion to the value of each immovable property. 4. The preceding subparagraph shall apply mutatis mutandis to the case where there are several persons who have furnished their own property as security for the obligation of another, and 5. As between a person who has furnished his own property as security for the obligation of another and surety, they shall be subrogated to the rights of the obligee in proportion to their numbers, provided that there are several persons who have furnished their own property as security for the obligation of another. They shall be subrogated to the rights of the obligee in respect of the balance excluding the part incumbent upon the surety, and in proportion to the value of each property. If, in the case mentioned above, the property is an immovable, the provisions of subparagraph 1 shall apply mutatis mutandis. Article 483, Partial Subrogation. 1. Where a person has performed a part of the obligation on behalf of the obliger by subrogation, he may exercise his right concurrently with the obligee in proportion to the value of the performance effected by him. 2. In the case mentioned in the preceding paragraph, the rescission or termination of contract by reason of non-performance must be done by the obligee only, and he must reimburse the person subrogated for the value of the performance effected together with the interest thereon. Article 484, Performance by Subrogation, Documents relating to obligation and security. 1. An obligee who has obtained full satisfaction of the obligation by performance by subrogation must deliver to the subrogee all the documents relating to the obligation and the article held in possession as security. 2. Where performance by subrogation has taken place in respect to a part of the obligation, the obligee must enter the fact of subrogation in the documents relating to the obligation, and must allow the subrogee to supervise the preservation of the article held in his possession as security. Article 485, Loss or diminution of security by obligee and discharge of person entitled to constructive subrogation. Where there is a person entitled to the rights of subrogation in accordance with the provisions of Article 481, and the security is lost or diminished by the obligee's intention or negligence, such person shall be relieved of his liability in so far as it has become impossible for him to be reimbursed by reason of loss or diminution. Article 486, Extinction of obligation otherwise than by means of performance and subrogation. The preceding 6 articles shall apply mutatis mutandis to the case where a third person has made the obliger's obligation extinguished by the deposit or at his own expenses. Subsection 2 Deposit. Article 487, Requisite and effect of deposit for performance. If the obligee refuses to accept performance or is unable to accept it, the person effecting performance may relieve himself of his obligation by depositing the subject matter of performance for the obligee. The same shall apply where the obligee cannot be ascertained without any negligence on the part of the person effecting performance. Article 488, Method of deposit. 1. The deposit must be made with the deposit office in the place for the performance of the obligation. 2. If there are no special provisions of acts in respect of the deposit office, the court must, on the application of the person effecting performance, designate a deposit office and appoint a custodian of the deposited article. 3. The depositor must, without delay, give notice of the deposit to the obligee. Article 489, Recovery of deposited article. 1. Until the obligee has given his consent to the deposit or has notified the deposit office of the receipt of the deposited article or a judgment declaring the deposit effective has become final and conclusive, the depositor may recover the deposited article and, in such case, the deposit is deemed not to have been made. 2. The preceding paragraph shall not apply where a pledge or a mortgage has been extinguished by making a deposit. Article 490, Deposit of proceeds. If the subject matter of performance is unfit for deposit, or there is any danger of its perishing or being damaged, or excessive expense is required for deposit, the person effecting performance may, with the permission of the court, sell the subject matter by official auction or for value at the market price and deposit the proceeds. Article 491, Acceptance of deposited article and performance of reciprocal obligations. Where the obliger is to effect performance concurrently with the counter-performance of the obligee cannot take delivery of the deposited article unless he effects his performance. Subsection 3 Set off. Article 492. Requisite for set off. 1. If two persons are bound to each other by obligations whose subject is of the same kind and both of which have become due, each obliger may make a set off to the extent of the amount corresponding to that of his obligation, provided that this shall not apply where the nature of the obligations does not so permit. 2. The preceding paragraph shall not apply to where the parties have declared an intention to the contrary, provided that such declaration of intention cannot be so set up against a third person acting in good faith. Article 493. Method and effect of set off. 1. A set off be effected by means of a declaration of intention to the other party. No condition may be attached, nor a time be fixed, to such declaration of intention. 2. The declaration of intention for a set off shall be deemed to extinguish the obligation to the extent of the same amount when each obligation is eligible for a set off. Article 494. Set off of obligations which are to be performed at different places. A set off may be effected even where each obligation is to be performed at different places, provided that the party who effects the set off must compensate the other party for any damages which have arisen therefrom. Article 495. Set off by claim with completed extinctive prescription. A claim with completed extinctive prescription may be used for a set off if it had been able to be used therefore prior to the completion of prescription. Article 496. Prohibition of set off against obligation arisen from intentional unlawful act. Where the obligation has arisen from an intentional unlawful act, the obliger cannot avail himself of a set off against the obligee. Article 497. Prohibition of set off against obligation of which attachment is prohibited. If the claim is one of which an attachment cannot be effected, the obliger may not set up against the obligee any defense of set off. Article 498. Prohibition of set off against obligation under garnishment order. A third obliger under garnishment order may not set up against his obligee who requested such order any defense of set off subsequently acquired by him. Article 499. Provisions to be applied mutatis mutandis. Articles 476 through 479 shall apply mutatis mutandis to a set off. Subsection 4. Novation. Article 500. Requisite for an effect of novation. If the parties have entered into a contract by which the essential elements of the obligation are modified, such obligation shall be extinguished by novation. Article 501. Novation by change of obliger. A novation by change of an obliger may be effected by a contract between the obligee and the new obliger, provided that it shall not be effected against the intention of the original obliger. Article 502. Novation by change of obligee. A novation by change of an obligee cannot be set up against a third person, unless it is done by a document with a certified fixed date. Article 503. Novation changing obligee and effect of consent of obliger. Article 451. 1. Shall apply mutatis mutandis to a novation by change of an obligee. Article 504. Case of non-extinguishment of original obligation. If the new obligation arisen from a novation does not come into existence or has been avoided by reason of illegality of its cause or of any circumstance of which the parties were not aware, the original obligation shall not be extinguished. Article 505. Transfer to new obligation of security. The parties to a novation may transfer the security for their original obligation to that of the new obligation, within the limit of its objective, provided that if the security has been furnished by a third person, his consent must be obtained. Subsection 5 Release. Article 506 Requisite for an effect of release. If the obligee declares to the obliger an intention to release the obliger from the obligation, such obligation shall be extinguished, provided that a release cannot be set up against a third person who has a reasonable interest. Subsection 6 Merger. Article 507 Requisite for an effect of merger. If a claim and the corresponding obligation become vested in one and the same person, the claim shall be extinguished, provided that this shall not apply if such claim itself is a subject of a third person's right. Section 7 Debts payable to order. Article 508 Form of assignment of debt payable to order. A debt payable to order may be assigned by means of endorsement on and delivery of the instrument. Article 509 Endorsement to party liable on instrument. 1. A debt payable to order may be assigned even to its obliger by means of endorsement. 2. An obliger who has been assigned the debt payable to order by means of endorsement may assign it by means of re-endorsement. Article 510 Form of endorsement. 1. An endorsement must be written on the instrument or on a slip affixed thereto, and the endorser must sign or write his name and affix his seal on it. 2. The endorsement may be made by means of leaving the endorsed unspecified, and it may be made by means of simply a signature of the endorser or the name and seal of an endorser. Article 511 Form of disposition of informal endorsement. If an endorsement has been made in an informal way according to paragraph 2 of the preceding article, the holder may dispose of it in the form of each of following subparagraphs. 1. His own name or the name of some other person may be written as an endorsee. 2. An endorsement may again be made on the instrument in an informal way or by means of indicating some other person as an endorsee, and 3. The instrument may be assigned by means of delivering it to a third person without indicating the endorsee, and without endorsing it. Article 512 Effect of endorsement payable to bearer. An endorsement payable to bearer is equivalent to an informal endorsement. Article 513 Effect of establishing title by endorsement. 1. The possessor of an instrument is deemed to be the lawful holder if he establishes his title to the instrument through an uninterrupted series of endorsements. The same shall apply even if the last endorsement is in an informal way. 2. If an informal endorsement is followed by another endorsement, the endorser of this last endorsement is deemed to have acquired the instrument by the informal endorsement. 3. Cancelled endorsements are deemed not to be written in connection with the uninterrupted series of endorsements. Article 514 Effect of establishing title a bona fide purchase. No person can require the lawful holder of an instrument to give it up, provided that this shall not apply if the holder acquired it, he was aware that the assigner did not have title, or was not aware of it owing to gross negligence. Article 515 Endorsement transferring rights and personal defenses. The debtor of a debt payable to order cannot set up against the holder defenses arising from his personal relations with the previous holders, provided that this shall not apply if the holder has knowingly acquired the debt payable to order to the detriment of the debtor. Article 516, Place of Performance. If the place of performance is not determined by the instrument, the present place of business of the obliger shall be the place of performance. If he has not the place of business, his present domicile shall be the place of performance. Article 517, Presentation of Instrument and Performance Delay. Even where the time for performance is determined by the instrument, the obliger shall be in default only when the holder has presented the instrument and demanded performance after the time for performance has commenced. Article 518, Right and Duty of Debtor to Verify. The debtor is bound to verify the regularity of the series of endorsements, and he has the right, but is not under any duty, to verify the genuineness of the signature or name and seal of the endorser, or the identity of the holder, provided that if, when the debtor effected payment, he was aware that the holder is not the person having the right or fails to know it owing to gross negligence, the payment shall be null and void. Article 519, Performance and Delivery of Instrument. The debtor is bound to effect performance only in exchange for the instrument. Article 520, The Claim to Subscribe Receipt of Instrument. 1. The debtor, when he effects performance, may require the instrument to be receipted by the holder. 2. In the case of partial payment, if the debtor requires, the obligee is bound to make mention of this payment on the instrument. Article 521, Lapse of instrument by procedure of public summons. The instrument which has been destroyed, or has become separated from the possession of the holder may be voidable by the procedure of public summons. Article 522, Deposit or Performance by Procedure of Public Summons. When there exists a cause for application for a public summons, it may cause the obliger to deposit the subject matter of the obligation, and it may cause the obliger to effect performance, if the holder furnishes adequate security. Section 8, Debts payable to bearer. Article 523, Form of Assignment of Bearer Security. A debt payable to bearer may be assigned by means of delivery of the instrument. Article 524, Provisions to be applied mutatis mutandis. Articles 514 through 522 shall be applied mutatis mutandis to a debt payable to bearer. Article 525, Debt payable to named obligee or to bearer. The instrument in which the obligee is named with an additional statement that the payment is to be made to the holder, is equivalent to a debt payable to bearer. Article 526, Instrument for Discharge. Articles 516, 517 and 520 shall be applied mutatis mutandis to the instrument issued by the obliger in order to escape from the responsibility by means of effecting performance to the holder of the instrument. Chapter 2, Contract. Section 1, General Provisions. Subsection 1, Formation of Contract. Article 527, Binding Force of Offer of Contract. An offer of a contract may not be withdrawn. Article 528, Offer of Contract Specifying Period for Acceptance. 1. An offer of a contract specifying a period for acceptance shall lose its effect if the offerer does not receive a notice of acceptance within the period specified. 2. Where a notice of acceptance had arrived after the expiration of the period mentioned in the preceding paragraph, if it was dispatched at such a time that under normal circumstances it would have arrived within such period, the offerer shall dispatch, without delay, to the other party a notice of the delayed arrival, provided that this shall not apply where a notice of the delay has already been dispatched by the offerer before its arrival. 3. If the offerer has neglected to give the notice mentioned in the preceding paragraph, the notice of acceptance shall be deemed not to have been delayed. Article 529. Offer of contract not specifying period for acceptance. An offer of a contract which does not specify a period for acceptance loses its effect if the offerer does not receive a notice of acceptance within a reasonable period. Article 530. Effect of delayed acceptance. The offerer may regard a delayed acceptance as a new offer in the cases of the preceding two articles. Article 531. Time contract inter absence comes into existence. A contract inter absence shall come into existence at the time a notice of acceptance is dispatched. Article 532. Formation of contract by realization of intention. Where no notice of acceptance is necessary either by reason of declaration of intention to that effect by the offerer, or by reason of custom, the contract shall come into existence upon the occurrence of an event which may be taken as a declaration of intention to accept. Article 533. Crossed offer. Where offers of the same content are sent to each other, the contract shall come into existence at the time when each of the two offers has reached each other party. Article 534. Acceptance with modification. If the offeree has accepted an offer but subject to a condition or with any other modification, he shall be deemed to have rejected the original offer and thereby simultaneously made a new offer. Article 535. Culpa in contrabando. 1. Where a contract, whose objective is unattainable, is concluded, a party to the contract who was aware of, or should have been aware of such unattainability, shall be liable for damages suffered by the other party who relied upon the contract is valid, provided that the amount of damages to be recovered may not exceed the profit which would have occurred if the contract was valid. 2. The preceding paragraph shall not apply where the other party was aware of, or should have been aware of such unattainability. Subsection 2. Effect of contract. Article 536. Exceptio non adem pleti contractus. 1. One of the parties to a bilateral contract may refuse performance of his own obligation until the other party tenders performance of his obligation, provided that this shall not apply where the obligation of the other party is not due. 2. If one of the parties to a contract is bound to tender performance of his own obligation first to the other party, and if there is any significant cause existing by which the other party's performance becomes difficult, the body of the preceding paragraph shall apply. Article 537. Obliger's burden to bear risk. If the performance of an obligation of one of the parties to a bilateral contract becomes impossible by any cause for which neither of the parties is responsible, the obliger may not be entitled to counter-performance. Article 538. Impossibility of performance due to cause for which obligee is responsible. 1. If the performance of an obligation of one of the parties to a bilateral contract becomes impossible by any cause for which the obligee is responsible, the obliger may demand counter-performance. The same applies to cases where performance becomes impossible by any cause for which neither of the parties is responsible in the case of mora creditoris. 2. In the cases of the preceding paragraph, if the obliger has received any benefit by being relieved of his own obligation, he shall return such benefit to the obligee. Article 539, Contract in favor of third person. 1. Where a party to a contract has agreed therein to effect an act of performance in favor of a third person, the person may demand such act of performance directly from the obliger. 2. In the case of the preceding paragraph, the right of the third person shall come into existence from the time when he declares to the obliger his intention to accept the benefit of the contract. Article 540. Obliger's right to demand third person's answer. In the case of the preceding article, the obliger may, with a reasonable period fixed, demand the third person to answer whether or not he will receive and enjoy the benefit stipulated in the contract. If the obliger has not received a definite answer from the third person within such period, it shall be deemed that the third person has refused to receive the benefit stipulated in the contract. Article 541. Establishment of third person's right. The right of the third person which has come into existence in accordance with the provisions of Article 539 shall not be altered or extinguished by the parties. Article 542. Obliger's right to defend. Defenses incidental to the contract mentioned in Article 539 may be set up by the obliger against the third person who is to receive the benefit of the contract. Subsection 3. Rescission for the future and rescission of contract. Article 543. Right of rescission for future or of rescission. 1. If, pursuant to the contract or the provisions of acts, one of the parties or both parties have a right of rescission for the future, or a right of rescission, either right of rescission shall be effected by a declaration of intention made to the other party. 2. The declaration of intention mentioned in the preceding paragraph may not be withdrawn. Article 544. Delay of performance and rescission. If one of the parties does not perform his obligation, the other party may fix a reasonable period and give peremptory notice demanding its performance, and may rescind the contract, if no performance is effected within such period, provided that if the obliger declares in advance his intention that he will not effect such performance, no peremptory notice shall be required. Article 545. Periodic acts and rescission. If, according to the nature of the contract or by a declaration of intention of the parties, the objective for which the contract has been entered is unattainable unless it is performed at a designated time and date or within a designated period, and one of parties has not effected performance on his part, the other party may, without giving the notice mentioned in the preceding article, rescind the contract. Article 546. Impossibility of performance and rescission. If performance has become impossible for any cause for which the obliger is responsible, the obligee may rescind the contract. Article 547. Indivisibility of right of rescission for future or of rescission. 1. Where there are several persons as parties to each side of a contract, a right of rescission for the future or a right of rescission of the contract shall only be effected by or against all of them. 2. If, in the case mentioned in the preceding paragraph, the right of rescission for future or the right of rescission has lapsed against one of the parties, it shall also lapse as against the others. Article 548. Effect of rescission and restitutio in integrum. 1. If one of the parties has rescinded the contract, each party shall be liable to restore his other party to his original position, provided that the rights of third persons shall not be prejudiced thereby. 2. Interest shall be paid upon any money to be repaid in the case mentioned in the preceding paragraph as from the day on which such money has been received. Article 549. Restitutio in integrum and exceptio non adimpleti contractus. Article 536 shall apply mutatis mutandis to the case mentioned in the preceding article. Article 550. Effect of rescission for future. If one of the parties rescinds a contract for the future, the contract shall lose its effect for the future. Article 551. Rescission for future or rescission and claims for damages. Rescission for the future or rescission of a contract shall not affect any claim for damages. Article 552. Right of peremptory notice as to whether other party exercises right of rescission or not. 1. If no period is fixed for the exercise of a right of rescission, the other party may demand of the person entitled to rescission to make a definite answer by fixing a reasonable period as to whether he rescinds the contract or not. 2. If no notice of rescission has been received within the period mentioned in the preceding paragraph, the right of rescission shall lapse. Article 553. Extinction of right of rescission due to injury, etc. If a person entitled to a right of rescission has by his intentional act or negligence materially damaged the subject matter of the contract, or has become unable to return it, or has caused it to be converted into a different kind of object by processing or altering it, the right of rescission shall be extinguished. Section 2. Gift. Article 554. Meaning of contract of gift. A contract of gift shall become effective when one of the parties declares his intention to transfer property of his own gratuitously to the other party and the other party agrees to accept it. Article 555. Contract of gift not in writing and its rescission. A contract of gift which is not in writing may be rescinded by either party. Article 556. Acts of donee and rescission of contract of gift. 1. The donor may rescind a contract of gift in favor of the donee for the reasons as prescribed in the following subparagraphs. 1. If the donee has committed an act of crime against the donor, his or her spouse or lineal relatives by blood, and 2. Where the donee is under duty to support the donor, but does not perform this duty. 2. The right of rescission mentioned in the preceding paragraph shall be extinguished after the lapse of 6 months from the day on which the donor was aware of the occurrence of any cause of rescission or at the time when he has declared an intention of acquiescence. Article 557. Change of donor's property status and rescission of contract of gift. The donor may rescind a contract of gift if after the conclusion of a contract of gift the donor's property status has been adversely changed and the donor's living has become gravely affected by the performance of contract of gift. Article 558. Rescission and portion as to which performance of contract has been completed. Rescission of a contract of gift in accordance with the provisions of the preceding 3 articles shall not have any effect in respect of any portion as to which performance has been completed. Article 559. Donor's liability for warranty. 1. A donor shall not be liable for any defect or deficiency in the thing or right which forms the subject of his gift, provided that this shall not apply to where he was aware of such defect or deficiency and has nevertheless failed to inform the donee thereof. 2. In respect of a gift subject to a charge, the donor shall assume the same liability in respect of warranty as that of a seller to the extent of such charge. Article 560. Gift for periodical performance and lapse due to death. A contract of gift for periodic performance shall lose its effect upon the death either of the donor or of the donee. Article 561. Gift subject to charge. The provisions relating to bilateral contract shall apply to a gift subject to a charge, in addition to the provisions of this section. Article 562. Gift effective upon death. The provisions relating to testamentary gifts shall apply mutatis mutandis to a contract of gift which is to become effective upon the death of the donor. Section 3 Sale. Subsection 1 General Provisions. Article 563, Definition of Sale. A sale shall become effective when one of the parties agrees to transfer a property right to the other party and the other party agrees to pay the purchase price to the former. Article 564, Unilateral Promise to Sell or Purchase. 1. A unilateral promise to sell or purchase shall become effective as a sale from the time when the other party declares his intention to complete the sale. 2. Where no period is fixed for the declaration of intention mentioned in the preceding paragraph, the person who has made a unilateral promise may give a peremptory notice to the other party to give a definite answer within a reasonably fixed period as to whether he will or will not complete the sale. 3. If the other party fails to give an answer within that period, the unilateral promise shall become void. Article 565, Earnest Money. 1. If one of the parties to a contract of sale has delivered, at the time of entering into the contract, money or other things under the name of down payment, assurance deposit, etc. to the other party, unless otherwise agreed upon between the parties, the deliverer by giving up such money, and the receiver by repaying double such money, may rescind such contract before one of the parties has initiated performance of the contract. 2. Article 551 shall not apply to the case mentioned in the preceding paragraph. Article 566, Burden of expenses relating to contract of sale. The expenses relating to a contract of sale shall be borne by both parties in equal shares. Article 567, Mutatis mutandis application to contract for value. This section shall apply mutatis mutandis to contracts for value other than sales, provided that this shall not apply in the case where the nature of such contracts does not so permit.